Is this the microphone I should use right here?
Either one. You can use
Either one?
stationary or
Yeah, this is fine. My name's Chip Sharp. I work at Cisco Systems. However, I have to say that nothing in this talk really has anything to do. Well, I can't say that anyone necessarily at Cisco agrees with what I have on here. So this is all more or less a personal talk. It doesn't have anything to do with Cisco's position on any matters before the FCC or anything else like that. So don't misunderstand that particular issue. So I did have put a disclaimer in here to that effect at the bottom of the first slide. So what I want to talk about today is this issue of CALEA. I don't know if any of you followed the Raven mail list and some of the things that went on in IETF and some of the issues in terms of wiretapping. And what I wanted to talk about today is what is CALEA? What is it not? What is not CALEA? What's the difference between CALEA and wiretapping? And then try to talk a little bit about what the implications on the internet service providers and the internet in terms of the CALEA law and what's going on in some of the court cases right now. And I have somewhat of a selfish reason for agreeing to give this talk, and that is that I'm hoping to interest some people in the room to get more active in the CALEA, some of the CALEA efforts that are going on in the industry right now. And so if anybody's interested afterwards, please see me after the talk, and you have my email address right here, and please feel free to send me an email if you're interested in finding out what more is going on, and if you're interested in getting involved. So first I want to start out with, what is CALEA? CALEA is an acronym, of course. It stands for Communications for Law Enforcement Agencies Act. It was passed in 1984. The numbers underneath there are just some numbers that I don't understand, but they somehow reference the law and the official Thomas Registry and the other legal things if you're interested in that kind of thing. But if you do a search on CALEA, that'll pull up more than you really want to know. And to boil it down into one statement, what it says CALEA is requirements for carriers to assist law enforcement agencies in carrying out wiretaps. And what that means is that it's a requirement for you to assist them in carrying out wiretaps. It doesn't define any new wiretaps that the law enforcement agencies are allowed to have, which I put here is that theoretically at least, CALEA does not grant law enforcement agencies any more authority or power to wiretap anybody than they already have under law. What it does require is that it does specify what assistance is required from a carrier to give to the law enforcement agency when they do issue a wiretap warrant. So it's a subtle difference between the two, but there's a lot of misunderstanding in that area in terms of what it means and what it doesn't mean. Now the caveat of that is, of course, that new authority is a matter of interpretation. Okay, so with any law that comes out before Congress, I guess I've come to understand they're all very vague in how they're worded, and it's rather ambiguous. So anytime this comes along, then some people will try to interpret the law to give them more authority than they had before. But the initial intent was not to give any more new authority, but to require carriers to assist the law enforcement agency in carrying out the warrants that they already have a right to give. I'm not going to go through this. It's just up there to look through. If you're interested, you can get it off the web. But this is out of the congressional report after the law was passed, and clarifying what the Congress's intent was in passing CALEA. And it does say fairly clearly that it doesn't allow the law enforcement agencies any more rights or any more different wiretaps. It is just to allow the required carriers to help them with the wiretaps, but also to protect privacy in the face of new technologies and to avoid impeding development of new technologies and blah, 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 and so forth and so on. All the good words they like to have in there. But this isn't in the law itself. This is in the congressional report that came along with the law, which is supposed to give the congressional intent. The surveillance laws themselves. Okay, these are the actual laws that define wiretaps. What can be wiretapped? What kinds of wiretaps are provided and allowed, and so forth and so on. So if you're issued a warrant for a wiretap, it'll probably be under one of these laws. So there's Title III of the Omnibus Crime Control Act of 1968. That was updated by the Electronic Communications Privacy Act of '86. And then there's Foreign Intelligence Surveillance Act. Now, one interesting thing I heard from one of the a guy from law enforcement is that, and I'm not sure if this is true or not, but so it's hearsay, is that more full content wiretaps are actually, carried out under the Foreign Intelligence Act as opposed to the Omnibus Title III Act. So, the full content is where they get everything. So it's just a little bit of information. Terminology, I'm going to go through this briefly just so there's some clarifications of what some of the terminology is. And I was warned, by somebody who reviewed this for me that, right about now, people's eyes will start glazing over and everybody will be reading email. So, I'll try to catch your attention again when there's important points that I want you to pay attention to. Okay, terminology. The reason terminology is important because there are laws written using words, and the words supposedly mean something, and it's where it gets into the courts, when the courts start interpreting what these words mean, is how it starts affecting people like you and me and everybody else. So, CALEA discusses what the requirements are for telecommunications carriers in helping law enforcement to carry out the wiretaps. So, of course, it's important to know, am I a telecommunication carrier or not? And those are things that we have to deal with. So, CALEA defines a telecommunications carrier. I won't go into this. I'm not going to read this word for word. You can read it yourself on your own time. But it's basically someone who carries communications. It kind of uses the term common carrier for a carrier. Someone here it is. But then there's item B here too is interesting, where it says it defines telecommunication carrier. Then it says a person or entity engaged in providing wire electronic communication switching or transmission service to the extent that the Commission finds that such a service is a replacement for a substantial portion of the local telephone exchange service, and it's to the best public interest to do so. So you can think, well, do I fall into that carrier? Do I fall under that definition? It's kind of vague, of course, because it gives the FCC the latitude to declare when you are a telecommunications carrier and when you're not. So the other important thing, but it does not include persons or entities that are engaged in providing information services. And another caveat that gives them leeway to do whatever they want, depending on how they feel later on, C2, which says any class or category of carrier that the Commission feels like they don't want to include. And that's my wording, but you can read it. So it gives the FCC a certain amount of leeway in terms of how they define these things. And by the way, the word commission in here is assumed to mean Federal Communications Commission. So, we've already got some ambiguity in here. The term telecommunications service is used through, I just put this up there because it reminded me of the thing that comes up when it's not getting any signal over here. The term telecommunications service is used in the CALEA law every now and then also in the FCC's third report and order, which is their report on their interpretation of how the CALEA law should be implemented by carriers. However, you will be hard-pressed to find a definition of telecommunications service in either CALEA or in the FCC third report and order. So they use this term telecommunications service, but they don't necessarily define it. And as anybody who's been associated with this knows, that where it ends up getting defined is in the courts. This is my interpretation, but it seems to happen more often than not. So there's a term telecommunications service which isn't defined. The only telecommunications service that anyone has actually figured out is something like voice is, of course, the big one. I did mention to one guy from the FCC that, you guys probably wouldn't be interested in this kind of stuff if voice over IP hadn't become such a big topic these days. And he didn't really have any comment on that. But, he did indicate that it did raise the awareness level in the FCC of the internet when people started talking about providing voice carrier services over the internet. Okay. Next, call identifying information. This comes along a little bit later, but the term call identifying information is defined as a term which basically means the signaling information identifying the origin and definition and destination of a call. Okay. Or a communication generated or received by a subscriber by means of equipment, whatever, blah, 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 blah. Okay. So, we always have this argument, there's no such thing as a call on the internet. The connection with service is no calls. However, the counter-argument has always been, well, this doesn't necessarily say call, it says each communication generated or received by a subscriber. And some people would like to interpret that as each communication means each packet. where a packet is a separate communication, in which case it comes along later on where call identifying information would be something like source destination IP address. Information service. This is an important definition because the law says that people or entities providing information services are not included under the law, CALEA law. Now, one of the lawyer guys pointed out to me, who asked to review this, is that doesn't mean that they're precluded from providing all this information. So if you want to go out and provide this information on your own time, then that's not against the law. But what it just says is the CALEA, the law, does not apply to entities that provide information services. So here's the definition of information services. You can look at it. There's a lot of words in there, but it includes, in B, it tells more specifically what it does include, such as electronic publishing, electronic messaging services, and things like that. So there are some services you can think of that do fall in, that are kind of obvious, that fall into this category. And then there are some services that might become kind of a gray, ambiguous area. For example, well, I'll go on and see, it does not include any capability for a telecommunications carrier's internal management, control, or operation of the network. So that item C is not included in the definition of information service. Now, I'm not sure exactly what the implications of that are, but it can't be good, whatever it is. Now, one of the interesting things that I brought up into some of the discussions I've been in terms of, you notice that electronic messaging is included under information services. So the definition of electronic messaging is in CALEA, and here it is right here. So software-based services, sharing of data, images, sound, writing, other information among computing devices controlled by senders and recipient. Well, the key word there is sound, right? When I'm talking, I'm producing sound. So there's a vague, there's an area of interpretation that needs to be done in terms of, is voice over the internet an information service? It's carrying sound, and therefore it kind of falls under electronic messaging as well. So there's another ambiguity that's, people have different interpretations. It even gets better when you're talking about doing voicemail. So if I record something and attach it as a WAV file to an email and send it to another person, is that considered voice over IP? And they listen to it and then re-record another WAV file and send an email back to me. Is that considered an electronic messaging information service, or is it considered a telecommunications service like voice over IP? These are some of the things that have not been interpreted yet. Safe harbor standards. What this means is that a safe harbor standard is a standard, well, it says right here, it's a standard adopted by an industry association or a standards organization that defines how to carry out CALEA, defines the protocols or whatever for carrying the information required by CALEA to the law enforcement agency, okay, to meet the requirements in CALEA. So note that it doesn't say that this has to be an official standards organization like TIA or T1S1 or whatever. It doesn't say that at all. It just says a industry association or standard setting organization can define a safe harbor standard. And what that means is that if you're a carrier or if you're an equipment vendor, if you meet a safe harbor standard, then you are not liable for contempt if a law enforcement agency comes and issues a warrant. If you deliver the information as per the standard and you implement the standard, then you can't be held liable. Then you're deemed as having met the requirements of CALEA by definition. All right, so it gives you a certain amount of safe harbor from the law enforcement agency coming back to the judge and saying, this person, this carrier is not providing reasonable assistance, and therefore I want you to issue a contempt citation against them, that kind of thing. Okay. Before I go further, that's the terminology bit, and I'll go through the different types of surveillance. But one thing I want to make clear, again, when discussing the difference between wiretap laws and CALEA, is that under Title III in the Foreign Intelligence Service Act, it already has in there that a carrier that served with a wiretap warrant is required to provide all reasonable assistance to serve that warrant. Okay, so it's already in there without CALEA ever existing. There's a requirement to provide all reasonable assistance. Now, the definition of all reasonable assistance is not necessarily clear. So as I spoke to an FBI lawyer at one thing. He mentioned a case to me where they served a warrant, wiretap warrant, on a internet service provider. The internet service provider said something to the effect, okay, go ahead. And the FBI said, no, we want you to do this. And they said, no, we don't have to do that. And so the FBI then went back to the court, got the judge to issue a contempt citation, not necessarily a contempt citation, but issue a court order telling the carrier what exactly they were supposed to do under threat of contempt, which then the carrier, the service provider, according to this person, said, oh, that's what you wanted, and then proceeded to help the law enforcement agency carry out the wiretap. So I'll try to attribute some of this information to where that comes from, so you can use your best judgment as to how valid it is. So according to the FBI lawyer, CALEA is a two-edged sword. On one, it defines things you have to do, but on the other hand, it restricts what you have to do to what's in the CALEA Act, so that the law enforcement agency can't make up, or a judge can't make up new things you have to deliver to the law enforcement agency. So that's their view of the world anyway. By the way, I was kind of curious, how many people here have been served with a wiretap warrant that want to admit it? Okay, we've had a few. So we've had a few that have had the joy of experiencing these things. And so it is happening today. Without CALEA, there would still be wiretap warrants served, and there would still be a thing you would have to deal with. So the types of surveillance that are defined in Title III. Okay, there's something called a pen register. These are terms you might hear. You'll hear these words come up in any discussion of CALEA and all these wiretap laws. So we might as well understand what they are. Pen register is a wiretap of the phone numbers that a target is calling. So if they got electronic surveillance on me, and they have a pen register warrant, then whoever I call, they have the right to collect the phone numbers of everybody I call. And that's all they have the right to collect under a pen register. By the way, the law enforcement agencies call wiretapping electronic surveillance, so that's the same thing as far as I'm concerned, but they consider it different. Trap and trace is the opposite of a pen register, which is that they have a trap and trace warrant, wiretap on a person, say on me. That means that if anybody here calls me, they have the right to collect the phone number of everyone calling me under a trap and trace warrant. And they only have the right to collect the phone number of everyone who's calling me. So that's a trap and trace. Full content is what it sounds like. Is they have the ability to collect everything about calls for anybody I'm calling or calling me. So any communications over the line. That includes what everybody seems to always think of as wiretaps, which they get to listen in on everything I say. All right. So those are the three basic types of wiretaps. One important thing to remember in thinking about all the legal mumble jumble that's going on in the court cases and everything is that there's a lower barrier for getting a wiretap pen register or trap and trace warrant than there is to get a full content warrant. So you can actually get a trap and trace or pen register warrant a lot easier than you can get a full content or Title III under FISA. There's a much higher barrier. So that comes into a court case I'll talk about a little bit later in terms of what's delivered to the law enforcement agency. And again, there's also a concept under the law called minimization in the 1968 law, which means that the FBI or the law enforcement agency, whoever it is can get more information than they're entitled to get, but they're required to minimize that and only pay attention to the things that they're allowed to get. Okay. Right? So there are many precedents. There's precedents for this. For example, there are cases where they're only allowed to listen in on conversations of a particular person. So that means that they listen on the phone. Okay, if someone else, like that person's wife, their kids, whatever, uses their phone, they're required to turn off the tape recorder and stop listening when someone else uses the phone. Or they're not allowed to use that in court, basically. So that's the concept of minimization. Another one is if it's in foreign languages, they're allowed to record everything that's on the wire, then give it to an interpreter who then makes the decision of whether it's relevant or not, and then interprets into English for them to actually understand what the people are saying. So that's the idea of minimization. Requirements on carrier equipment. So the requirements under CALEA are provide the law enforcement agency with access to intercept all wire and electronic communications to and from the target. That's under a Title III or FISA warrant. Call identifying information, which we discussed earlier. That would be, say, for a pen register or a trap and trace. And then correlation, which means you have to correlate the target, basically it's more or less a timestamp and a warrant, and be able to allow them to correlate it with the warrant that they served and the information they served. So there's some amount of correlation they're required to do. They're required also, under the carrier equipment, to minimize interference with service. What that means is that the target shouldn't be able to know that they're being surveilled, or whatever the word is. So you're not allowed to affect the service to the extent that they are able to detect that they're being, wiretapped. In addition, you're not required to do things that are going to cause you to affect your customer service by providing a wiretap. So if there are cases, things which they might want you to do, which would actually, degrade your network, you're not required to do that. So that's one thing. And also, carriers are required to protect privacy. And that is requiring to protect the privacy of people who are not under surveillance in delivering information to the law enforcement agency. So that's a brief summary, and really, you have to go and read the law for yourself and talk to your lawyers and get interpretations of that. So I'm just trying to give you a brief overview without going into horrendous detail. It also provides limitations to what's allowed and what's required. The law does. For one thing, the law does not allow you to provide location information other than what's available via the phone number. So you're required not to provide location information to the law enforcement agency, and that would be something like the address or whatever, where the person's located. And that's important for a later lawsuit, for one of the later lawsuits that's currently outstanding. Another one is information services are not included, private networks are not included. So if you're running a private network, then you're not required to provide this information under CALEA, but still there's Title III to keep in mind. Now, the definition of private network is kind of vague, so that's another legal interpretation. The next one I think is pretty important, which is that no decryption is required. So if a user is encrypting their data from or calls or whatever from one place to another, the carrier is not required to decrypt that information flow, except if the carrier has keys, then they have to decrypt. Okay? So if you're providing a service to a customer, well, not you necessarily, because you all might be information service providers and may not be required. So we'll see about that. So anyway, if a carrier is providing a service where they hold keys that allow them to decrypt the user's information, then they're required to decrypt the information to deliver to the law enforcement agency, which might have some implications on some of the things that have been discussed recently. Okay. Also, there's a limitation in that you're supposed to protect the privacy of non-targets. Current standards efforts. Now, we talked about safe harbor standard earlier. Currently, there's only 2 efforts underway that kind of relate to Internet that are considered safe harbor standards. The first one is the official TIA standardized JSTD 025. That was first finished, the first draft version of that was done in 1996, I think, and they just updated recently and is out for letter ballot now to become an ANSI standard, which is supposed to cover telephony and packet data. So that covers all the call events and everything that are supposed to be delivered under a PIN register and trap and trace, as well as the content delivery. It defines data formats for delivering the information, how the information should be delivered, so forth and so on. It was developed by TA TRR 45.2, which is a wireless standards group. So, I'll talk about that a little bit later, but it's really oriented toward voice and wireless IP and things like that. And it's written by TIA, so it kind of follows their normal standards message formatting. So all the messages are in ASN.1 that are sent, so forth and so on. And also I believe, if I remember correctly, the preferred delivery mechanism for delivery of this information to the FBI or to the LEAs is via X25. And, I brought up so I've got a customer who has a gigabit Ethernet connection to me, and I'm going to deliver this in IP ASN.1 encoded encapsulated over X25 to the law enforcement agency. Good luck. But so anyway, that's the upper ballot for an American national standard. There's also packet cable. I'm not sure if anybody is familiar with packet cable. There's Cable Labs have defined a standard for voice over IP over cable networks. The intention is for that to also be a safe harbor standard for the cable industry. Right? TCIA has developed a paging safe harbor standard, and IETF, the last bullet item, I got a lot of flack about. Some people thought of it as being kind of pejorative, but I meant it not to be pejorative, which is the IETF declined to play in this area. They published RFC 2804, which is the Raven. I totally agree with their decision not to develop a safe harbor standard for Internet for the reasons they give, mainly. However, it's kind of unfortunate in that there is no body, group, or organization in the United States that is interested in developing a safe harbor standard for IP. So therefore, it defaults over to TIA, which is a wireless standards organization. So I'll just get a brief overview. You can get the standard yourself. Unfortunately, you have to pay for it, but that's how TIA works. Two levels. They have a call data channel where you deliver the PIN register information, call event information, and call content channel where you deliver all the information to them if there's a Title III. The only IP-specific definition is for wireless IP. What that means is there's no code points for IP in general. There are only code points in the messaging for wireless IP. Somehow wireless IP is different from, I'm not sure what the difference is. Like I say, the scope is vague. The current solution, and this is important in the court case, is outstanding. The current solution in the joint standard right now is if you are delivered a PIN register or trap and trace warrant, you deliver everything, the whole packet stream over to the law enforcement agency, and you let the law enforcement agency only use that information they're allowed to use. Okay, so that's the current joint standard solution for doing PIN register and trap and trace. Okay, the FCC third report and order. It's released August 31st, 1999. It's the FCC's final interpretation of the CALEA Act and how it applies to carriers. It also responded to a lot of FBI requests. The FBI did not think that the joint standard went far enough and did not give them all the information they needed under CALEA to carry out whatever they needed to do. So the FCC ordered TIA to go back and revise the joint standard to include all this information that the FBI requested. They did not allow two things. I don't remember what the two things were that they didn't allow, but they required everything except for those two things. One interesting one I put on here right now is location ID. So the joint standard, the FCC ordered the TIA to go back and put location ID into the joint standard. Now, if you remember, CALEA specifically disallowed location information from being provided. So, go figure. Anyway, that comes up in the court case coming on. And in red, I put here, they didn't know what to do with packet. I mean, if you read, you can go and get the third report and order online and read it if you want to. But the end result is they didn't really know what to do with packet mode information. They didn't have enough information. They didn't know enough, so they invited TA to go back and gave them a year to provide a report on packet data surveillance and provide more information on what can be done. And I'll go into that a little bit later, what specific guidelines of that were. But basically, it was how do you separate call identifying information from call content to protect privacy in a packet mode network. The compliance deadline for delivery of packet data using Joint Standard 25 is currently September 30th, 2001. So September 30th, 2001, all carriers are expected to comply with Joint Standard 25, including packet mode. The call event information, the deadline is June 30th, 2000. Now, I should let you know that some law enforcement agencies interpret the law to mean, or interpret this to mean that if you're providing voice over IP services, you're required to comply with Joint Standard 25 by June 30th, 2000, by the end of this month, not by the September 30th date. So they interpret these statements as meaning that if you're offering voice over IP services as a carrier, then you're required to comply with this by this summer, not by next year. Now, not everyone agrees with them, of course, but I'm sure that'll be settled eventually. So right now, with the joint standard as currently written, September 30th, 2001 is the date. Now, there is a court case I mentioned that was currently pending. The USTA, CDT, EFF, and ACLU filed a suit challenging the FCC third report and order. Basically, they said the FCC ignored all the provisions in CALEA for privacy. They went way beyond the provisions that are allowed for privacy and for delivering information, and that, this should be, the third report and order should be basically, at least parts of it, stricken. So what they're opposing is the punch list items. This is a buzzword, but basically things like location ID. They're saying delivery of location information is specifically not allowed under CALEA. The FCC required them to do it, therefore it's illegal and the court should strike that. They also protested the packet data solution in saying that sending all data on a PIN register and trap and trace violates the privacy provisions of CALEA. So if you remember, I went back, PIN register and trap and trace is basically the phone numbers of the people you're calling and who are calling you. And that the joint standard was, their solution was just to send the FBI, or LEA, I'm sorry. LEA is the acronym for Law Enforcement Agency. I've been using that term, but send the LEA everything, all the packet stream, and let them figure out what they need. Now, also remember, one of the arguments in the court case is that the barrier for getting a PIN register and trap and trace warrant is lower than getting a full content warrant, which is fairly high. So the argument is that a law enforcement agency can get basically, in effect, a Title III wiretap with only the barrier of getting the warrant of a PIN register and trap and trace. Now, the counter argument that the FBI and the law enforcement agencies have are that, well, we have minimization already has precedence. It's already recognized method of operation. We aren't allowed to use anything above the PIN register and trap and trace information in court. So anything we get that's not allowed, we can't use it in court. So therefore, this is a valid way of doing it, of delivering the information. So that's my own interpretation of the summaries of some of the arguments that are being given. Okay, so the initial arguments were heard on 18th of May. There have been some press releases. You can go to techlawjournal.com, and they've got some information on that, and there are various other resources that reports on what happened on the first opening arguments. My own personal opinion on this, and this is not based on any legal training, which I have none, because I've never actually had a law course in my life, so I'm not a lawyer, is that the court will probably advise the FCC to go back and reconsider its position. Okay, so it'll probably give some, writing or finding, castigating the FCC for being lenient or telling them what good job they did or some wording, but the net effect is they'll probably remand it back to the FCC saying, you need to reconsider this, these things are not allowed, go back and think about it. Okay, the FCC will probably at that point do another notice of inquiry. There'll be another round of public comment, and then there'll be another FCC report sometime in the future. But time moves on, even if that happens. So, remember I said the FCC requested the TA to go back and issue a report on packet mode technologies. So the TA has started, initiated what's called a joint experts meeting. Okay, so gather people experts from the industry to get together and to write a report for the FCC on packet mode technology. So it's a technical fact-finding body. One of the scope of the meeting was not to get into legal interpretations of the law and so forth and so on, but to just look at the technical information that's available. So bullet item 2 was basically the scope of the GEM, which is determined feasibility of delivering less than the full content of packet to law enforcement agency under a PIN register or trap and trace. Okay, and the input has to be provided to TA for their report, which is due by September 30th. The scope of the GEM includes pretty much everything. There's nothing that I know of that's excluded. It does not include, again, legal issues, interpretations of the orders, impacts of encryption, other than how does it affect your ability to deliver the information. The status is the first GEM was held in the first week of May in Las Vegas. I attended the GEM meeting. My impression that most of the people who were there were from the wireless industry. There was almost no input from ISPs. There were a couple of people who were from a company who had a subsidiary that was an ISP. But I did not see much input from the Internet Service Provider community at that meeting. The meeting report's online. I have I give some pointers to them, and the current draft report is also online for you to look at and comment on if you want to. The second gym is scheduled for the 27th to 29th of this month, where they're hoping to finish the draft report, finish up all their work, and be done with it. Again, the web page for that is right there, and that web page also has all the contributions that were presented to the gym. It has information on how to register, how to get hotel information for anybody who wants to participate. And also, you can also provide contributions to the gym to participate. This is run like a normal standards meeting in TA, whereas things are run off of contributions. So if you don't have contributions, they're not necessarily considered. So the best way to get your view or opinion considered is to write a contribution, submit it, and then it has to be taken into account. It doesn't mean there's not discussions and things, but they do run by contributions. Status of the gym, main points right now is that everybody basically threw up their hands and said, there's no way to figure out what a difference is between an information service and a telecommunications service. The only way, well, at least my point of view is, if a carrier is offering a telecommunications service, then they know that they're offering a telecommunications service. So it's kind of a truism, but it does have some interpretations later on. So there are two identified scenarios. One is a service provider is offering a call management service, say a SIP server, H323 gatekeeper or something, and is offering a voice service, telecommunication service, to its customers via a SIP server. Therefore, it has access to certain information, call information for voice over IP. And there's a service provider offering IP transport, which isn't doing, all it's doing is routing packets. It's not doing any fancy things, just normal IP transport. So those are the two scenarios that they identified to take into account in the report. And then they realized, at some point, they tried to cover everything under one report. So they tried to cover everything concerning ATM, frame relay, IP, X25 under one thing, and they finally realized that it's impossible to do that. So they have a main section which is general principles, and then appendices which are technology dependent on each technology. And so there's an appendix for IP. Let me go back. So anyway, that's basically the status of that right now. You can look at the report online. As it turns out, it's kind of like this whole CALEA thing is work for me personally. I'm not sure exactly how I got sucked into all this, but I'm looking back thinking, how did I get involved in this, and how can I avoid getting involved in these kind of things in the future? But somehow, in the room at the time, it seemed reasonable that I volunteered to be the editor of the appendix for IP. I had second thoughts about it, but as it is, I am the editor for the appendix for IP. If anybody's interested in seeing it and commenting on it and providing me input to what it should say and what it shouldn't say, please let me know, and I'll send you copies, or I'll send you a pointer to where it's located. And you can then look at it and read it and see if it's totally off track or whatnot. And I will value any input you have on that. Because it would be better to have more input into the process from the Internet community than only from the people I've been dealing with so far. Personal conclusions. This is actually the most interesting part of the thing. Unfortunately, I had to go through the rest of it to get to this point. Separating IP header information, such as IP addresses, from content is technically feasible. Okay. What that means is that it's technically feasible to actually deliver IP address information for a target to a law enforcement agency under a PIN register or trap and trace warrant. Okay. Now, I would like to have said it wasn't feasible, but unfortunately, we can do it. So, if I stated in a meeting, you can't do this, and then they brought out, well, here's the config command for iOS to do it, and I'd say, well, okay, I was wrong. There are caveats to this, of course. Okay, reliably identifying application. I worded this very carefully, by the way, so the words in here actually are there for a reason, but reliably identifying applications in a packet as telecommunication service or information service is not technically feasible. Okay. What that means is that the end result of that is that there are people in the law enforcement agency who want you to sniff packets and suck out SIP invites or H.325 setup and get the information, even if you're not offering a voice over IP service. Okay? And the precedents they use is one of the things that's under argument now is that the FCC has required telecom carriers to provide in-band DTMF information to the law enforcement agency under a PIN register warrant. That means after you call, you call like a 1010-350 or something to get to the carrier, and then you get the little beep, and then you dial in the final, or not 1010, but you dial an 800 number, you get a beep, you dial the phone number of the person you're calling, and then your credit card information, and you make a phone call. Well, previously, you would just provide the 800 number that you dialed to the carrier, and you wouldn't necessarily be required to provide the in-band. But under the interpretation now, the carriers are required to sniff out the DTMF digits that are sent in-band and delivering them to the law enforcement agency. Now, of course, there's no way for the carrier to tell whether you're calling a long-distance company for a voice call or I'm calling my bank and doing a bank transaction using DTMF digits on my phone. So what it means is that the carriers are required to deliver that information even if it's a bank account codes and other transactions, because there's no way for a carrier to know the difference. So some people are using that as a precedent and saying, well, the internet providers or IP carriers should be required to sniff the packet contents for things like SIP, invites, things like that. What I'm trying to do is say, no, that's not technically reasonable. So, now you can do it in some cases, and in some cases you can't, but really reliably there's no way to do it. Increasing line speed and encryption aggravates the situation. When you start offering gig downlinks to customers or even meg downlinks to customers, it's going to cause a problem in delivering all this information to the law enforcement agency. And also will adversely affect the ability for your equipment to serve their customers, because all the cycles you're spending on copying packets and copying headers and everything and sniffing to send to LEA is cycles you're not spending routing packets. New operating procedures to reply to warrants. One thing to keep in mind is, when the FBI or a law enforcement agency shows up on your door with a warrant, how are you going to respond? So you might have to think about what kind of operating procedures you're going to have to put into effect in your network in order to reply to such a warrant. Trade-off between protecting privacy and burden on the ISP. Okay, there's a lot of technologies that are available and things that you could do to protect your customers' privacy. But it's just my opinion in looking at it right now is that you can do more, but it's more work for you. So the easiest thing may be to do is just to ship everything off to the law enforcement agency and let them figure it out, right? But that doesn't necessarily protect the privacy of your customers. You could do more than that, and by narrowing down the amount of information you send to the LEA, but the amount of work you're spending narrowing down the information you send to the law enforcement agency is more work that you have to do in your systems, your equipment has to do, and so forth and so on. So there's a trade-off between privacy and burden on the internet service provider. An example of that is the proposal we've kicked around internally about authenticating information sent to the law enforcement agency. And that is basically digitally signing the information you send to the law enforcement agency so that if it is altered in some way between then and the time it goes to court, there's a way of knowing that the information was altered. Now, the technology, I think, might be there to do that now or in the near future, but again, it's more work and more things that you have to deal with. Seizing stored communications versus communications in transit. It's an important thing I was asked to bring this up is that things that you store is not applicable to wiretap laws. It's applicable to search and seizure laws. And anything you store over 180 days is actually a much lower threshold for getting a warrant to get that information. In fact, in some cases, the only thing that has to do is the prosecutor has to sign a subpoena to get it. Okay, so it doesn't even have to go before a judge. So all the information you're storing on customer information you're storing is potentially applies to a search and seizure. My next question, I'm just curious about who's going to be the test case. All right, so who's going to be the first? When is a law enforcement agency going to show up on a service provider's door with a warrant saying you have to provide this information under CALEA? And I'm not sure exactly when that will happen. I assume it will happen in the next couple of years. And really, as far as I know, nobody really knows what the end result of this will be. Everybody seems to assume that this will all be defined by the courts. And all these vague ambiguities and things I've mentioned will be defined by the courts. And that they will eventually define what is an information service, what's allowed, what isn't allowed, and so forth and so on. But I imagine there'll be a lot of angst and hand-wringing since then. So to sum up, I'm finished with the talk. Here are some references. You can get these. There should be available if you want to go read the laws and things like that. And the end result is, if you're interested in these things, try to get more involved in the process. Get more input from the service provider community would be useful. In the gym, if it goes to another FCC notice of inquiry, try to keep track of what's going on there and make your opinions heard. Otherwise, it will be defined by other people that may not have your interest in heart. Thank you very much. Pardon? I'm here for a while. Yeah. So any questions on this, please? Yes.
Hi. Hello. Hi. I'm not sure if you've covered this in talk, and I'm sorry if you did, but you said that there's a safe haven for any standards body that says you only have to provide X, Y, Z. Is there any reason, since the IETF declined, is there any reason somebody else can't individually write an RFC that says, hi, you don't have to provide anything if you don't feel like it, get it passed by the RFC editor, and then claim that's a standard?
Well, it's an idea. Yeah.
I'll write all 4 lines and submit it to it.
Well, I said that right. The law says that. It leaves a lot for interpretation because the Cable Labs packet cable spec, as far as I know, has not been blessed by the FCC as a safe harbor standard.
Oh, the FCC hasn't blessed the safe harbor standard? Hasn't
blessed the packet cable standard. But there's not necessarily anything in the CALEA law that says the FCC has to bless a safe harbor standard. It's very vague. So it's not clear what that means, right? Just like anything else in things coming out of Congress. It's not really clear what that means. So, yeah, I've had to actually explain what the IETF's position on this was many times because people have this, without reading it, they've got this idea of what the IETF did, which is wrong. But you're right. There is, if it is possible if an organization wanted to develop a safe harbor standard for IP, that they could do that and get that accepted as a safe harbor standard. And in fact, at the last GEM meeting, I did get, one thing I wanted to do is I did get them to agree to put into the report is that the end result of this for the TA joint standard may be referencing other organizations' standards. So there is a possibility of developing a safe harbor standard for IP and having it referenced in the TIA as a normative reference, for lack of a better term, as a safe harbor standard. And thanks, that's a good point, though, and it does bring up a good point about safe harbor standards. And one scary thing, I just read a report about the current court case, is the judge was using the joint standard to help him interpret the law. Whereas I know in the meetings, they try not to interpret any law. When writing the standard, they just do technical, Edward Teller kind of things. To write the standard as technical people without thinking about the law. So that seems to be a bad loop developing in that regard. Go ahead.
Sean Brown, Equinix. One addition I'd like to add is in most of the wiretap instances, the law enforcement agency is not a charity, and the carrier is actually allowed to charge the law enforcement agency for their time, their materials, and any additional work they have to do. But most carriers actually file that under a tariff and can turn off the law enforcement agency's telephones if they don't pay the bill, whereas the ISP may not have that choice.
Well, if you're the carrier, you can turn off their internet access. Yeah, that's a good point, though. Thank you for bringing that up. That is true. That was discussed, is that there are financial recourse for chargeback to the law enforcement agency for the cost you incur in doing the wiretap. And, some people have, jokingly, this is totally a jokingly, talked about, wiretap as a revenue-producing industry. But anyway, that's an important point, is that it's in the U.S. at least, you're not obligated to take all the financial burden. Other countries I've heard, you're not only required to provide them the information, but you're required to pay for the lease line back to their sites to deliver the information to them. So that's not the case here. So thank you. Yes, I'll take this over here.
Wouldn't just going off of Sean's statement, this is John Brownline Highway, going off of Sean's statement, wouldn't making sure that even on the ISP side, being able to charge back, wouldn't that be something along the Fifth Amendment, where the government's not allowed to take my property or whatever without giving me reasonable compensation for it? I mean, I'm not an attorney or anything.
Huh? What?
Well, I mean, you're taking time and resources and so forth
Right.
away from an ISP.
Oh, okay. So, right. Unreasonable
Right.
claiming of property or something like that. Yeah, I had no idea. Like I said, I'm not a lawyer.
Right.
I've never studied law, so that's something a lawyer would have to answer.
The other question is that really where I wanted to go, another question was, sounds like one of the things that a lot of ISPs could do is make sure we don't have really good expensive switches in our network where we can't provide a copy stream of the data. And then how do they get access to it? I mean, is CALEA going to be something that requires us to have to put equipment in place to be able to conform to these laws, or what?
My answer to that is it depends on what the courts decide.
Okay.
But one answer to that would be yes, is that you will be required to buy equipment and put it in place to deliver the information that's required under CALEA. That's one answer. The other answer is no.
True.
CALEA you're an information service provider, and it doesn't apply. So it depends on how the court cases work out. But my own feeling is that eventually you will have to have ways. But then there's Title III, remember, where you're required to provide all reasonable assistance. Okay, so what's the definition of reasonable? But eventually, someday, there will probably be it'll settle down to something like providing IP addresses under PIN register or trap and trace, and then full content, some way of tapping into the system to get the full
I
content.
certainly support the fact that we're doing a PIN trace or tap and trace, rather that we only provide the header data and not the payload.
Okay.
If that's going to be something, then that needs to be so that they're not getting that full content.
Okay, thanks. Yes.
Yeah, Scott Call, Advanced Telecom Group. We're CLEC, so we also have voice side. And on the equipment issue that was just brought up, the FBI has offered to buy us all of the gear we need to be CALEA compliant on the voice side, and I assume they would do something similar on the data side. And also...
Now, do you get to choose what you're buying, or do they just deliver it to you?
Well, for example, there are certain upgrades we need to do to Lucid 5 ESS so that it can have an IP stack running X25. And so stuff like that they're offering to do. Anything that would only help us do CALEA and wouldn't upgrade any other of our services, they've offered to pony up. And also, I don't know if it's a 5E exclusive thing or not, but there's also 2 employee positions defined in CALEA as the surveillance administrator and the security administrator as 2 individual roles within the company. Is that a CALEA thing, or is that just a general wiretap on a phone switch thing?
What was that again?
Well, there are 2 roles: a security administrator who would deal with the LEA, and then a surveillance administrator who would then receive the notes from the security administrator and actually do the surveillance without anyone else in the company knowing it was happening. That's one of the other things with the law, is that it's only need to know within the company.
Right, that falls under the new operating procedures, I think. But right, it is. There's a lot of other things that I didn't have time to get into, but you're only, if 2 law enforcement agencies provide a warrant to tap the same person, neither of them are allowed to know that the other person is tapping.
Right, and that's, in my understanding, is they have the...
And no one else other than people that need to know are allowed to know that this is happening. So there are operational implications of this, of course, which is like hiring people that, whatever people to come and take care of your security for you.
Yeah, I was curious if those were roles that were defined, because all of my CALEA stuff so far has been through the Lucid documentation on the 5ESS, and so I was curious if that was actually in the law to have the hierarchy of security and surveillance administration, or if that was just the Lucid model for doing it and conforming to CALEA. So.
Yeah, I can't answer that.
Thanks.
I think it's probably implied but not explicit. There's very little explicit you can find in these things. So, we'll ask one more.
Dan Golden with NetRail. Two interesting points to make is I was the respondent to two tap orders when I was at MindSpring, right after we merged with Earthlink, and the FBI came in, and two interesting points are, one, money is not an object for these guys. So if we're worried about them paying us or reimbursing us for our time, these guys do not care. It's not their money, it's our money, they're going to pay it to us anyway. And similarly, if the software creates needs, they will pay the money. They're very driven to get this information. The other thing is that the way technically they're usually doing this is they need switches that have mirror port capability. That is 99 times out of 100 how in a data situation they're pulling this data out. When they have a carnivore or some other kind of device they're putting on there behind what they call a one-way hub. But apparently it's mirror port technology is kind of the basis for what they're doing. So I wouldn't be surprised if at some point they required that the switches we use to back up dial-up ports, to back up DSL, had some kind of built-in capability for mirroring.
Well, yes. Thanks. Yeah, you're right. I mean, I can see, I think there already have been a few startups that have come along under the CALEA industry to do these things. To take, for example, take a span port off of an Ethernet switch, it just sucks the data off and spits it out. You could just ship it raw to the LEA, or you could attach something like, everybody here knows something you can use to pull off IP headers if given a data stream, right? So then there's various variants on that, security, encryption, all kinds of things that will take it and then spit out only the data, the information that the LEA is allowed to get.
The other kind of fascinating thing was that I said, if these guys are using any kind of encryption, PGP, whatever, you guys are going to be out of luck. And they said, no, these guys are all too dumb. They said that pretty much as a blanket rule, that they've never found anyone whose mail they wanted to read, and it's all email, by the way. That seems to be what they're looking for. They've never found anyone who they're looking for who actually encrypts their email.
Well, I just started. The problem is the people on the other side of the email have to be able to decrypt it. Unless you have two, it doesn't work very well. Pardon? Yeah, I could do that. I think that's all the questions, though. Thank you very much. I'll be around briefly.